Good evening, breaking news. Last week, our country was shocked by a land dispute tragedy between a lien holder and a borrower. The conflict sparked following a 3-month payment default. A source claimed that the lien holder has lost his right to apply for order for sale. Hence, we have 4 lawyers on board with us today to discuss this issue in our newly awaited segment, Law to Lawyers. Stay tuned for the next segment. Flora signing off. Thank you for streaming with Awani News.
Hello everyone, welcome to the new segment of Law to Lawyers. So for the first episode, we will be discussing the issue of land dispute between Murni and Ali, specifically on whether Ali has lost his right as the lien holder. First of all, we should discuss the definitions of lien. According to Section 281 of Subsection 1 National Land Code, lien is defined as the act of any proprietor depositing his issued document of title to another person as a security for a loan. That person may apply for entry of lien holder's caveat, and upon the entry of such caveat, become entitled to lien over the land or lease. There are two types of lien, which are equitable lien and statutory lien. Statutory lien occurs when the lender keeps the IDT as security for a loan and lodge a lien holder's caveat to protect his interest over the land, while equitable lien occurs when there is no lodgement of lien holder's caveat made. There are several elements that need to be complied for creations of statutory lien. The first element is the right to create lien belongs only to registered proprietor of the land. There is also an issue arise as to whether the borrower of the loan is not the registered proprietor. Is he valid to create a lien? So let's go. By looking at the case prior to 2008, third party cannot create a lien on behalf of the borrower. It was decided by the court that the right to deposit the title as security for a loan is restricted only to the proprietor, as what stated in the case of Peter Pichian and Ramasamy Chetty. While after 2008, the view is different. The third party can deposit IDP for the benefit of the borrower. However, the third party lien must create the lien with the instruction, consent, or authorizations of the proprietor. Thus, the actual act of depositing may be done by someone else. This can be supported in the case of Hong Leong Finance Berhad and Staghorn Senyum Berhad, whereby Abdul Aziz Muhammad Federal Court Judge, in his judgment, stated that Section 281 of Subsection 1 speaks of the registered proprietor depositing the IDP, but does not specify the borrower. He could see no reason for construing the loan to mean only a loan to the registered proprietor, as the loan may be a loan to a third party as well. It means that Section 281 Subsection 1 did not specifically prohibit the creation of lien by registered proprietor to secure a loan granted to a third party, as derived from the case of UGA Senyum Berhad and United Overseas Bank, Malaysia Berhad. In applying to the question, we shall first discuss the issue in which Murni wanted to purchase a land from Sam that is subjected to a restriction in interest, that it cannot be transferred, leased, or charged without consent from the state authority. Unfortunately, we cannot assume that there is consent given by the state authority, since it is not expressly stated in the question given. The act of signing the Form 14A does not necessarily be the end of the registration process, as anybody can sign the form beforehand, which later can be presented to the land office. That being said, although Murni and Sam had signed the Form 14A, it does not mean that the whole transfer has been completed. Murni still has yet to have the legal title over the said land. Thus, she cannot considered as the registered proprietor of the land as the transfer is not yet to be completed. In the second part, we shall focus on the creations of land. Since the land is subjected to the restriction in interest, the condition that needs to be obliged is only limited to what stated in the agreement, which only impose restriction to transfer, lease, or charge, as what we mentioned earlier. Thus, creation of lien supposedly to be allowed. So now we will be looking at the first element of creating a lien, which is it must be created by the registered proprietor as stated in section 281 subsection 1. In this case, Murni, who had applied a loan amounted to 30,000 ringgit from Ali by using Sam's land as a security transaction, is considered third-party lien. Since there are two positions and views for the validity of creating the third-party lien, we will be focusing on the second view, which is the rule applied after 2008. Applying the judgment in the case of Hong Leong Finance Berhad and Stockholm Sdn Berhad, the third party, which is the borrower, can create lien with the instruction, consent, or authorization of the proprietor. However, in this case, although a third party, Mumi, is entitled to deposit the title of Sam's land, but she has yet to get the authorization from Sam. It does not matter who should deposit the IDT, but it is important to get consent and will from the registered proprietor, which is Sam. In this case, Sam is not seen to give his authorization for Muni to use his land as the security transaction to get the loan. It only mentions that the land given to her was only for the purpose of registration to purchase the land, not for the purpose of creating lien. Therefore, the first element failed due to the matter of not getting the authorization from Sam.
Welcome. So now I will continue with the second element in creating the statutory lien. So the second element that needs to be taken into account is deposition of the IDT. According to section 281 subsection 1, lien arise when the borrower physically deposited the IDT to the lender and lender kept the IDT as the security of the loan. Therefore, in our case, lien here arise when Murni physically deposited her title to Ali and Ali kept the title as the security of the loan worth 30,000 ringgit. The issue that normally arises in regards to deposition of IDT is, does the lien holder would still have the right over the said land when he part the IDT? The answer is the lien holder would still have the right over the said land when he part the IDT, only if the lien holder lodged the lien holder's caveat. Section 281, subsection 4 authorized lien holder to part with IDT upon return request made by the proprietor or lessee, but it is restricted for the purpose of producing the IDT or duplicate lease at any registry or land office. By applying those laws in our issue, Ali still have the right over the land in Muar, although he part the title, since Ali has lodged the lien holder caveat in order to protect his interests. By referring to the section 31 subsection 4, Ali may part the title for the purpose laid under National Land Code. Since Ali's action of parting the title is for registering the charge, which falls under the National Land Code, thus he is authorized to do so, and this will not cause the lien to be lost. Additionally, he has no intention to abandon the title, and he has entered into lien holder caveat. Let us strengthen our point by referring to the Mania Kawasagam Chetty against McGregor, the 1993 case. The lien holder handed over the IDT to the land office for partition purposes. Upon the new title, no endorsement of the LHC was made, but the court stated that lien holder has not lost his land simply because he has no longer having physical possession of the IDT. Hence, the lien was still existed. Similarly, in our case, Ali's action of returning the title to Murni, i.e. parting the title, is for registering the charge purpose, which is under the NLC. Okay, and the national land code. Although Ali may no longer have the physical possession of the title, the lien with Murni is still existed. In conclusion, I would say the second element is fulfilled because Ali's action of parting the title is valid and he still possesses the right over the said land. That's all from me. Thank you.
Hi everyone, welcome back to the discussion. So now I'm going to proceed with the third element, which is intention to create lian. So intention to create lian need not be expressly documented. If it is stated in a document that there is intention to create lian, then that will be fine. However, the intention may be derived from the conduct of the parties. And this conduct includes oral forms or even written forms. So from now, we knew that it is a case-by-case basis and situation differs every time. So now I'm going to give you an example of a situation that gave rise to the presumption of intention. Okay, so let's say I am the borrower and Miss Flora is the lender. I applied loan from her and then she advanced the loan to me. And then we entered into a contract of loan. And this contract of loan this contract of loan entitled her to possess the title of my land. So from the situation we knew that the entitlement of the possession is actually to secure the loan she lent me. So from here, we knew that there is intention to create lien between me and Miss Flora. However, in this case, Morni deposited the title to Ali as the security for the loan she applied from Ali, which amounted to 30,000 ringgit. And this is stated clearly in the facts of the case. If we look at this alone, of course, we can assume and presume that there is intention coming from Morni to create lian over the land. However, I want to bring your attention to the case of Nalamal and Karupanan. In this case, it provided that element of intention is not satisfied if first, possession of IDT was obtained through fraud or misrepresentation, and second, the deposition of IDT as security was never authorized by the registered proprietor. In this case, there was no element of misrepresentation or fraud coming from Murni because when Murni first possessed the IDT, she did it legally. Sam gave the title to her because they were in the middle of making Murni the registered proprietor. They were in the middle of transferring the Sam's land to Murni. But then, after Ali approved her application of loan, she just deposited her title due to that. However, here, as discussed, she is still the third party of this transfer. She is still the third party of this whole scenario. This registered proprietor, the real registered proprietor is actually Sam. So, according to this case, Sam's authorization and consent is needed in order for the intention to be valid. Hence, majorly dependent to the case of Nalamal, we can conclude that the existence of intention to create lian is rebutted here. There's no intention made by Murni. That is all from me. Thank you.
Welcome back. My name is Mariam and I'm a managing partner from Dodo and Associates. So we have listened to the fruitful discussion from other lawyers pertaining to the first three elements of a valid lien. So today I'm going to discuss the fourth element, which if you fulfill the fourth requirement, it would establish a statutory lien instead of an equitable lien. So you may wonder, what is the difference between statutory lien and equitable lien? I will cater to this issue shortly, but first I'm going to explain the important elements of the lodgement of liens holding caveat. So when does a lien become an enforceable and a valid statutory lien? A statutory lien will be created upon the lodgement of liens holding caveat. So this means that prior to the lodgement of liens holding caveat, the lien holder will only be regarded as an equitable lien holder. So, what is the provisions under the National Land Code that governs the issue of lodgement of landholder caveat? So first, pursuant to Section 330 subsection 1, any person or body who has been deposited with the IDT as security for the loan may apply for the entry of landholder caveat in respect to the land in question. So this simply means that the person who is entitled to enter into landholder caveat is the party who has who is in possession of the physical IDT, i.e. the lender. Meanwhile, Section 330, subsection 2, stress that the application of entry of landholder caveat must be made in Form 19D, duly attested in accordance with Section 211, along with the prescribed fee and the issue of document title, or as the case may be, duplicated lease. So basically, Forms 19D contains a statutory declaration which the applicant must make, whereby he testified that the IDT has been deposited with him as security for the loan. So I think most of the audience are curious, what is the difference if we did not lodge the liens holder caveat? I mean, we are still regarded as a liens holder, right? Is it really necessary to enter into liens holder caveat? So as I mentioned earlier, if you enter into liens holder caveat, you will be considered as a lien holder with statutory rights. What does this mean? In the event of default by the borrower, you are entitled to revoke remedy under Section 281, subsection 2 of the National Land Code, in which the lender must obtain a judgment that from the High Court or the Land Office, according to case-by-case basis. Once judgment that is obtained, then the lien holder must apply to the court for an order for sale in accordance with Section 257 to Section 259 and Section 266 to Section 269 of the Code. The sale is required to be by way of public auction. So this is where the difference lies. By contrast, if the lien is uncaveated and remains so on default of payment, as an equitable lien holder, you only have contractual interest of the land. It means that you cannot invoke the remedies provided by the National Land Code in cases of default by the borrower. Unlike a statutory lien holder, a lien holder may invoke remedy provided under the Contract Act, such as specific performance and whatnot. So I hope that everyone can comprehend the difference between an equitable lien holder and statutory lien holder. So the caveat is unnecessary to create a lien, but it is necessary to protect it as a statutory interest and for the purpose of relief. So in regards to this issue, in our case, following Ali's act of entering into the lien holder caveat, he may be regarded as a statutory lien holder because as a party who owns the IDT, who is in the possession of the IDT, he is entitled to lodge the caveat pursuant to Section 330. However, a valid lien failed to be established in this dispute from the beginning because Ali failed to fulfill two requirements of a valid lien. So let me reiterate why there is an invalid lien from the beginning. First, Ali did not gain authorization from the registered proprietor of the land to create lien because in order to establish a valid third-party lien, consent from SAM as a registered proprietor is required because it is one of the conditions. Secondly, in regards to the third requirement, there is no valid consent because the deposition of IDT from Muni to Ali was not duly authorized by SAM. So in conclusion, the caveat had to be removed and Ali does not have any rights to seek remedy under Section 281 subsection 2 of the National Land Code, and for that reason, he has lost his rights to apply for order for sale. That's all from us. Don't forget to tune in to the next episode of Law to Lawyers. Till then, goodbye.